Item 1.
Yes. Yes, please.
May I have Lordship, please? My Lord, in this case, my Lord, basically the question of interest is involved, and the submission which I could understood from my friend's argument is that clause 54 is there in the contract prohibiting the interest, but since no pleading was there before the arbitrator tribunal, it was not decided, and arbitrator tribunal has granted the interest, pre-interest, penalty interest, and future interest, my Lord, we are not disputing and all that. So we have waived our right by not pleading all those things before the arbitrary tribunal, and rightly the arbitrary tribunal has not considered, and in view of that, the application under section 34 should not have been entertained and allowed, setting aside that part of the judgment with regard to interest. So far the other claims are concerned, my Lord, those are allowed. Even 34 in application under section 34, the commercial code, landed district has allowed all that. Only with regard to the interest, my Lord, we are concerned here. So, my Lord, if I have correctly understood, this is what he says, that 54 is there, clause 54 is there prohibiting, but since you have not taken that view, you have right. And to that extent, they have shown, my Lord, the decision of Susaka. Well, I'll deal with that, my Lord. I'm just.
Let us see 54 again.
Yes, my Lord. Because they are saying that 54 at my Lord will find in volume 2. If page 446, my Lord. May I read, my Lord? No. Yes.
When was the arbitral proceeding commenced?
My Lord, they agreed prior to 2005, but ultimately, since my Lord, there were some delays and all that, they approached my Lord.
No. Arbitral proceedings, when did they?
Started sometime in my Lord 2013, my Lord. 2013? 2013, my Lord. Just see the
3rd May 2012. 3rd May 2012.
I'm sorry, 3rd May 2012.
Enter into reference.
3rd May 2012.
He entered into reference on 3rd May 2012. What are you saying? In the reference.
The tribunal was constituted.
7 subclause A was always there.
Yes.
It did not come after the 15 amendment,
Yes,
2015.
it was always there.
It was always there.
It was always there, madam, from
Always.
very beginning. Now, my lord, your lordship wanted to see clause 54.
What are the heads of award? What are the heads of award?
It's my lord, the issue before the arbitrator was reimbursement of enhancement of minimum wages.
No,
There's
let us see the award.
539 volume 2. 539 volume 2.
Na? Why? Hmm? 501. Yes. It starts with my lord, volume 2, 501. My lord, में समराइज कहाँ किया है?
539.
539 समराइज किया है ना? 539. Payment towards reimbursement on account of escalation in minimum wages. Payment towards unjust deductions. Toward reinforcement, steal and refund of amount deducted. Payment towards reimbursement of 10% contracted profit. Payment on account of idle overhead charges from May such and such date. These are the 4 basic.
Please come to the heads of award.
my lord.
Heads of award.
Yes, my
Page
lord.
539.
It's about 439, my lord.
539.
539. My lord,
If
may I read? The amount payable on account of final bill nil, my lord. There is no claim.
No, apart from say item number 3, which can be stretched to mean that money which is lying with the corporation deducted and lying with the corporation, none of these awards relate to any money which is held by the corporation. Now you come to the exception clause, interest, barring interest.
54.
Page 446.
446, my lord.
No claim for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation.
Your lordship, that is true, my lord. That is one part of that.
So it doesn't cover this damage claim.
Well, your lordship, interest or damage will be entertained by the corporation with respect to any money or balance which may be lying with the corporation. Number one, owing to any dispute.
So this is not something which is lying with the
Right.
corporation.
And difference or, my lord, the claims are also, my lord, under disputes. Because there is the disputes in respect of those claims.
Another name for interest is damage. Another name for interest is damage.
Damage, my lord.
So whatever money is lying with the corporation, say on account of the contractor, if there is claim for that money, then no interest will be payable. But how does it cover? Item number 1 is not awarded.
Ma.
3, you can say payment towards unjust deductions. Deductions made and held by the corporation. No interest. But apart from that, 4, 5,
245.
2, 4, 5, how does the clause cover?
My lord, your lordship will kindly see the further I am reading 54, my lord.
Yes.
Or final payment or in any other respect whatsoever.
Or with any delay on the part
Yes.
of the engineer in charge making periodical or final payments.
Or in any other respect whatsoever. And my lord, this clause came for, my lord, consideration. Similar clause, my lord.
Money or balance which may be lying with the corporation owing to any dispute.
Difference or misunderstanding.
Owing to any dispute. Suppose there is no dispute or with respect to delay on the part of the engineer in charge. There is no dispute, but there is delay.
delay, then also, my lord, it will be.
Yes. But the money has to be held by the corporation.
So, my lord, in this case also, my lord, as per their, my lord, entire case, that they are entitled to the escalation in minimum wages, they are entitled to payment towards unjust deductions which has been made, then payment towards reimbursement of contractors, because, my lord, the contract was at a particular stage, my lord, it was closed, my lord, foreclosed. So, my lord, this actually, my lord, I'll come to later on, my lord, in the decision of, my lord, Saeed Ahmad and Company versus State of, my lord, Bihar. My lord, I'll refer to, my lord, I'll be coming to a different, my lord, I'll definitely refer to all the decision. My lord, all the decision, in fact, is same. Exactly the word by word is same, my lord.
Of the clause.
Same.
Supreme Court decision.
Exactly same. The number is different there. The number is there, my lord, is G109.
Maybe, yes.
Cross number is different.
Clause, my lord, the contents of the clause is same. And it has been held that there is prohibition and it cannot be granted.
By the Supreme Court.
Yes, my lord. I'll come to that, my lord.
No, you show us that first.
Yes,
Okay.
then
The comparison is
I'll give the comparison.
If the Supreme Court has said, then that is the end of the matter.
I think in two decisions, my lord, I'll be, and this particular case, my lord, which I am referring, ये दो, वो नहीं वो केस ये दो ना, ये केस का वॉल्यूम दो ना,
It's like a volume. ये वाला एक
my lord, if your lordship kindly take the judgment compilation. Well, I'm showing from this also, my lord, that chart has been prepared for convenience of my lord, my lord. If your lordship kindly look into page 1. Well, it was a 2009-12 SCC 26. It was a bench constituted by two judges, my lord, in Syed Ahmad and Company versus State of Uttar Pradesh and others. My lord, may I take to my lord paragraph 7 at page 5 directly, my lord, because other text may not be necessary. Paragraph 7 at page 5, my lord. A continuation, my lord, that paper book page 5, my lord. Internal page 30 of that judgment. My lord, may I read, my lord. The issue regarding interest as noticed above revolves around clause G 1.09 of the technical provision forming part of the contract extracted below. Now, my lord, I have read, my lord, subject to my lord's correction. The clause which clause 54 and this clause. We have given in the compilation both the our 54 and that clause G 1.09 in Syed Ahmad. No claim for interest or damages will be entertained by the government with respect to any money or balance which may be lying with the government, or any become due owing to any dispute, differences or misunderstanding between the engineer in charge on the one hand and the contractor on the other hand, or with respect to any delay on the part of the engineer in charge in making a periodical or final payment, or any other aspect whatsoever. Now, in para 8, the lordship discussed about section 3 of the Interest Act. Now, I am not reading the first part. Your lordship kindly come to page 6, the last part of para 8. Subsection 3 of section 3 provides that nothing in section 3 shall apply to any debt or damages upon which interest is payable as of right by virtue of an agreement, or to any debt or damages upon which payment of interest is barred by virtue of an express agreement.
Please come to paragraph 18 and 19.
18 and 19, my lord. In Harishchandra, a different version of clause 1.09 was considered having regard to the restrictive wording of that clause. This court held that it did not bar award of interest on a claim for damages or a claim for payment for work done and which was not paid. This court held that the said clause barred award of interest only on amount which may be lying with the government or by way of security deposit, detention money or any other amount refund of which was withheld by the government. In the earlier case, my lord, that was not the yeah. But in the present case, clause G 1.09 is significantly different. It specifically provides that no interest shall be payable in respect of any money that may become due owing to any dispute, differences or misunderstanding between the engineer in charge and contractor or with respect to any delay on the part of the engineer in charge in making periodical or final payment or in respect of any other respect whatsoever. The bar under clause G 109 in this case being absolute. The decision of Harishchandra will not assist the appellant in any manner. Now, my lord, if your lordship kindly, para 23. In para 22, they have referred to G.C. Roy case, but para 23, your lordship will kindly come. My lord, I am speaking the earlier part, para 23, 3, 3, 6, 7, 8th line, my lord. 8th line. Whether the provision in the contract bars the employer from entertaining any claim for interest or bars the contractor from making any claim of interest, it amounts to a clear prohibition regarding interest. The provision need not contain another bar prohibiting the arbitrator from awarding interest. The observations made in this context of interest pendatellite cannot be used out of contract. Now, para 24, last 4 line. My lord, because there was a reliance on the engineer's D space and other cases. In that context, it was said in para 24, it will be line about from the bottom, it will be 4th line. It is doubtful whether the observation in so and so in case arising under Arbitration Act 40 that arbitrator could award interest pendatellite ignoring express bar in contract is good law. But that need not be considered further as this is a case under the new act where there is a specific provision regarding award of interest by the arbitrator. Para 27, the conclusion, in view of above, we allow the appeal in part and modify the judgment of the High Court as follows. Judgment of the High Court setting aside the award of interest up to the date of award is affirmed. My lord, earlier, my lord, there were 3 types of interest, my lord. Pre-suit interest, pendatellite, and my lord, future interest. That is after award. But my lord, once my lord, this 31(7) has been incorporated in my lord, new act.
Yes.
New act, my lord, 2 types of interest remain, my lord.
This helps, this case certainly helps you very strongly, but with deepest respect to the Supreme Court, Harishchandra seems to have been correctly decided, and this perhaps not.
No, Harishchandra, my lord, the differentiation is, my lord, little different, my lord.
You have to read and understand the language properly. Disjunctive, conjunctive, prepositions, conjunctions, etc. Please come to this clause. But we are bound by the Supreme Court decision. No claim for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation. All right? Then the qualification, owing to any dispute, difference or misunderstanding between the engineer in charge on the one hand and contractor on the other. Money lying with the corporation on account of this misunderstanding or with respect to any delay not on account of misunderstanding or dispute, but on account of delay,
Delay, my lord, that is.
on the part of the engineering charge, making periodical or final payments, or in any other
Any respect whatsoever.
This is qualification of final payments.
That-
Lying with the corporation, one is or with respect to any delay, or the second disjunctive phrase, in any other respect whatsoever. So misunderstanding, delay, or in any other respect whatsoever, the money is lying with the corporation. Not that it covers all claims for profit, damages, money withheld, etc., etc. So if you interpret the language grammatically and correctly, the earlier decision of the Supreme Court seems to have made a correct interpretation of the intention of the
In the Harishchandra's case.
of the party. Yes, in my very humble opinion.
My lord,
But we affirm that we are bound by the decision of the Supreme Court. Yes, come to the next point.
so, my lord, so far,
So any other decision on this point,
yes.
on this clause?
There is a comparison.
Next, your lordship will find there, I have given at least,
Because in this case, the Supreme Court has considered that decision, that clause, and come to a different interpretation. That is why we are bound.
yes,
Had it not been considered, then we would not have been.
my lord, that would have been different, my lord, question. Your lordship would have interpreted it on my lord.
We could have followed either.
Yes, my lord, I have understood, my lord.
Yes.
My lord, seeing my lord, that interpretation, my lord, your lordship's humble view may not be correct, but since already Supreme Court has held, my lord, we are all are bound by
Bound
that.
by
Bound by that. All are bound by that.
Having considered the earlier decision and departed from it.
What's that? Two, my lord, serial number 2, that page 13, Tehri Hydro Development Corporation Limited and Jayaprakash Associates. तो बाउंड खोलने नहीं दिया है क्या? हाँ.
Compilation.
Compilation. Well, I have given all the decisions in the compilation.
Which covers that same identical language.
Well, identical language, there is another decision, my lord, that I'll. Ek minute. My lord, your lord, in this case itself, my lord, I am not saying that exactly, but virtually the same, my lord, if your lordship will kindly see. My lord, your lordship will kindly directly come to paragraph 14
Which case?
of this case. Page number 13, my lord. Tehri Hydro Development Corporation Limited versus Jayaprakash Associates, 2012, 12 SCC 10.
Yes.
My lord, may I directly take to my lord to paragraph 14 at page 19, my lord. My lord, may I read? This will lead to the court to a consideration of what is the principal bone of contention between the parties in the present case, namely the issue with regard to payment of interest. Clause 1.2.14 and 1.2.15, on which much argument has been advanced by the learned counsel for both the sides, may now be extracted below. No claim for delayed payment due to dispute, etc. The contractor agrees that no claim for interest of damages will be entertained or payable to the government in respect of any money or balances which may be lying with the government owing to any dispute, differences or misunderstanding between the party, or in any respect of any delay or omission on the part of the engineer in charge in making immediate or final payment or in any other respect whatsoever. Now, this part of 1.2.14 is maybe virtually the same as that of clause 54 in our case. Now, next is no omission on the part of the engineer in charge or to pay the amount due upon measurement or otherwise shall vitiate or make void the contract, nor shall be contractor be entitled to interest upon any guarantee or payment in arrears, nor upon any balance which may on final settlement of his account due to him. This clause is not the earlier part that covers our case. A reading of the aforesaid two clauses of the contract agreement between the parties clearly reveal that despite some overlapping of the circumstances contemplated by the two clauses, no interest is payable to the contractor for delay in payment, either interim or final. For the works done or on any other amount lying in deposit by way of guarantee, the aforesaid contemplated consequences would be applicable both to situations where withholding of payment is on account of some dispute or differences between the parties or even otherwise. Now, in this case, in para 16, Crafters engineering case was considered, then Saeed Ahmad case was also considered in para 16, my lord, at page 20. I am not reading here again, your lordship will
No, come to 19, this is different. There is no loss of profit or damage claim is involved.
Yes.
Only a non-payment issue. That is covered by the clause,
Yes.
as we have said. But the first case you cited is more.
More relevant. It is more relevant.
This only deals with those final provisional bills, final measurement, payment withheld, etc.
And my lord, if your lordship kindly come to, my lord, what I am again trying, my lord, in the context of their argument I am saying, my lord, because your lordship has seen 54, my lord, there is
Any other case on this clause?
case law, my lord, directly on those, this clause is not there.
No, there is all right. These two cases will do.
But
One more is there. Jay Prakash.
2019 J. Prakash.
Serial number 8.
my lord, I'm just serial number 8, my lord, page 74. सेम कॉन्ट्रैक्ट नहीं है It is a case of 1917 SCC 786 reported Jayaprakash Associate Limited versus Tehri Hydro Development Corporation India so and so. My lord, may I take your lordship to para
Page 79. Page 79. Page 79.
नहीं वो तो नहीं है
Page 21.
My lord, para 3, page 79. It may be pointed out that on interpreting clause 50 and 51 of the general condition of contract, the view taken by the High Court is that these clauses categorically provide that no interest would be payable to the contractor on money due to him. The said clauses is under. My lord, if your lordship kindly skip, then clause 5.1. No claim for interest or damages will be entertained or be payable by the corporation in respect of any amount or balance which may be lying with the corporation owing to any dispute, differences or misunderstanding between the parties or in respect of any delay or omission on the part of the engineer in charge for making immediate or final payments or in any other respect whatsoever. Then para 17, they have considered the other cases. Para 17 is important. That is at page 87. पहले भी है. In this whole conspicuous and keeping in mind in particular that present case is regulated by 1996 Act. But in the earlier paragraph, it said that was an earlier case. We have to decide the issue at hand. At this stage itself, it may be mentioned that in clause 50 and 51 of the GCC put a bar on the arbitral tribunal to award interest. My lord, I'm not emphasizing on the word, my lord. At this stage itself, it may be mentioned that in clause 50 put a bar on the arbitral tribunal to award interest. The arbitral tribunal did not have any jurisdiction to do so. As pointed out above, right from the stage of arbitration proceeding till the High Court, these clauses are interpreted to hold that they put such a bar on the arbitral tribunal. Even the majority award of the arbitral tribunal recognize this. Notwithstanding the same, if awarded the interest by relying upon the Port of Calcutta's case, the High Court, both single bench as well as the division bench, rightly noted that the aforesaid judgment was under 1948 and the legal position in this behalf have taken a paradigm shift, which position is clarified in Saeed Ahmad's and companion case. My lord, I have already read that. This rationale given by the High Court is in turn with the legal position which stands crystallized by Katina of judgments as noted above. Another reason given by the High Court is equally convincing. Clause 50-51 of R perimetria with clause 1.2 so and so of GCC in Tehri Dam's case, my lord, the earlier case which I referred, 2012. Those clauses have been interpreted by holding that no interest is payable on claim for delayed payment due to the contractor. Same construction adopted in respect of this clause, which in effect is a case between the same parties, is without any blemish.
This practical.
Huh?
It's under case to prosecuted.
Para 19. Now, my lord, Harish Chandra case was also considered in this case. In this backdrop, the only argument of the appellant, para 19, that remains to be considered as to whether such a construction is contrary to the judgment in Harish Chandra's case. Now, my lord, if para say complete answer to this, my lord can skip over all this. Para 24, finally, ultimately it holds. Para 24 at page 91. The upshot of the opposite discussion would be
21 to above.
21. I'm sorry, may I take to para 21, page 89, my lord. It is also pertinent to note that judgment in Saeed Ahmed's case distinguished the restrictive wording of Harish Chandra has been consistently followed by this court in number of cases thereafter. In this scenario, when we find that Harish Chandra case, which is of a vintage of 1948, and is distinguished in Saeed Ahmad's case, coupled with the fact that ratio of Saeed...
We have understood when the first case is pat on the point, helping you on all fours, why cite these decisions where a confusing set of facts, whether damage claim, whether delayed payment claim and all that, you are complicating your own case. When the first case you cited said that in all respects, interest is barred. End of the matter. Why cite these cases where complicated facts are involved? Mixed claims, damages, some payment, some days, this is allowed, this is disallowed. And show us the case they cited.
Hello?
He cited a case, Susaka or something.
He cited a case of Susaka.
You would distinguish. You want to cite any case on the waiver point?
My lord, my argument will be, my lord, my submission will be that Susaka is, my lord, a case on the facts of that particular case, my lord. It is not a judgment in re, my lord, and is not applicable to the facts and circumstances of the present case.
Yes.
My lord, before that, my lord, kindly 31(7) once again, my lord.
Yes. Unless otherwise agreed.
My lord,
That is how it starts.
and that has been, my lord, interpreted in the Bright Constructions case, and thereafter recently in 2022, my lord. Well, I'll place those decisions before my lord. That Bright Constructions case in the, my lord, judgment volume
Page 30.
serial number 4, my lord,
Page 30.
page 34.
Not so.
ये जजमेंट 4 वाला हमारा नोट 4 का my lord, it was a decision by my lord 3 judges. This clause was considered, my lord, in 2003 also, my lord, and thereafter also, but I am not showing all the decisions. My lord, para 13 at page 38. May I read, my lord? Section 31(7) of the Act, by using the word unless otherwise agreed by the parties, categorically specifies that the arbitrator is bound by the terms of the contract so far as award of interest from the date of cause of action of date of award is concerned. Therefore, where the parties has agreed that no interest shall be payable, this line is the arbitral tribunal cannot award interest.
There are 14 also maybe.
17 होता है.
The next basically.
Para 13.
13, my lord. And if your lordship kindly, again, my lord, I am not reading all this, my lord, your lordship will kindly, para 17. And 18 I will read, my lord, at page 39. It is also pertinent to note that G.C. Roy's case has been decided on 12/12/1991 on the basis of the provisions of the Arbitration Act 1940, which was not operative at the time when the dispute on hand was decided by the arbitral tribunal. Para 18. Section 31(7)(a) of the Act ought to have been read and interpreted by the arbitral tribunal before taking any decision. This fact is very important, this part. Before taking any decision with regard to awarding interest, the said section, which has been reproduced herein above, gives more respect to the agreement entered into with the parties. If the parties to the agreement agree not to pay interest to each other, the arbitral tribunal has no right to award the interest penalty.
All right.
My submission basically, this 2022 decision, my lord, also, my lord. But I am trying to, my lord, please before my lord, my lord, that, my lord, question of waiver will not arise, my lord.
In the facts of this case.
That was Susaka is in his facts of his case, my lord. Your lordship will kindly see the Honorable Supreme Court tried to find out whether they have said something in 11 also. But when they find that they have not made any whisper, the Supreme Court says that then no, they have waived the right.
You cannot raise it in the public.
Now, my lord, 2022 9 SCC, my lord, that is not in the branch, my lord, I am giving separately to my lord.
Page.
My lord, it is not in the judgment volume, my lord, I am giving separately. It has been 2022 9 SCC 286. Now, my lord, the important paragraphs. My lord, 16, my lord, section 31 has been, my lord, quoted. And Hyder Consulting has been referred to there, my lord. Now, my lord, your lordship kindly come to para 17. It could thus be seen that the part which deals with the power of the arbitral tribunal to award interest would operate if it is not otherwise agreed by the parties. If there is an agreement between the parties to the contrary, the arbitral tribunal would lose its discretion to award interest, and which will have to be guided by the agreement between the parties. My lord, in this decision, it was said, my lord, that whether there was a prohibition or no prohibition, well, the party may agree also that for this much amount the interest will be paid, for this much amount interest will not be paid. Now, in para 18, we find that in the present case, the word unless otherwise agreed by the parties would assume significance. That has been, my lord, considered in N.S. Nayak and Sons, my lord, I am not reading that. Also, Kamachi Amlan constructions, that has been considered, my lord, in para 18 and 19, that has been said, my lord. Now, my lord, para 20, at page 296 of that, my lord, judgment. if clause A of subsection 7 of section 31 is given a plain and literal meaning, a legislative intent would be clear and that a discretion with regard to grant of interest would be available to the arbitral tribunal only when there is no agreement to the contrary between the parties. This phrase, unless otherwise agreed by the parties, clearly emphasizes that when the parties have agreed with regard to any of the aspects covered under clause A of subsection 7 of the Act 1996, the arbitral tribunal would cease to have any discretion with regard to the aspect mentioned in the said provision. Only in absence of such agreement, the arbitral tribunal would have a discretion to exercise its power under clause A of subsection 7 of section 31 of the Act. The discretion is wide enough. It may grant or may not grant interest. It may grant for the entire period or any part thereof. It may also grant interest on the whole or any part of the money. Then we note para 24. Para 24 at page 297, it says,
You see, all those are just paraphrasing the section. It takes you nowhere. Those pronouncements. Unless otherwise agreed means parties agree, parties don't agree. That will take you nowhere. In claim 2 in the arbitration, there is a claim for pendent late interest. Page 51. Or rather, claim 7. You're in the counter statement dealing with claim 7. You have said nothing. If by the ordinary principles of pleadings you go, averred in the plaint, not denied in the written statement, what is the effect?
My lord, but true, my lord, your lordship, clause 54 has not been specifically stated in the, my lord, defense statement.
And second, not argued in arbitration, not taken in section 34.
Yes, 34 it is.
You have yourself said that on a conjoint consideration of the facts, does it or does it not amount to agreeing that you will get pendent late interest? The section says, unless otherwise agreed.
True.
That is the only point. These decisions of the Supreme Court are paraphrasing the section. This will take you nowhere.
No, but
and the facts you say.
No, so far the my lord, clause 54 was, my lord, never specified in any of the, my lord, written statement. But we have not specifically stated that clause 54 comes.
No, it is all right. That is an agreement between the parties. An agreement can be novated, modified, waived by further agreement.
There is no agreement to that effect.
Now, whether by this conduct there is waiver.
My lord, in my humble submission, not, my lord. Because, my lord, we have not, my lord, we have taken this point, not specifically 54. We said that this is, my lord, barred by contract, my lord. Prohibited by contract.
It is all right, agreed. Your first decision you cited, agreed. It is barred by the contract. But the subsequent conduct, now you come to 31(7). Unless otherwise agreed.
Yes, we have taken.
31(7).
Yeah, 37(1), my submission is, my lord.
Unless otherwise agreed. You have agreed. No interest. If you would have stopped there, no interest. Subsequent conduct, you have relaxed that agreement by waiver.
My lord, in my humble submission, my lord, not.
If you want time, you please get ready on that.
Tomorrow, my lord, tomorrow matter is fixed, my lord. Tomorrow the matter is fixed. I can place.
You will be able to finish tomorrow.
Yes.
How much time you will take?
Depending on what.
Tomorrow or.
Right now, what has been argued, another 10 minutes. I need about 10 minutes.
How much you will take?
No, no, I'll take some time because, my lord, I have to show, my lord, entire pleadings because my lord is, my lord, saying that I have not pleaded at all. But that is not in 34 very specifically pleaded and argued also, my lord. In written submission also it was there. My lord, what was there orally argued?
You are coming from Delhi. You will be able to come again, or shall we take it up tomorrow?
My lord,
It is better some more time is given to this matter.
we can have it some.
You tell us.
My lord, we have agreed to a date, my lord. Earlier, my lord, if possible, my lord, if necessary, that 25th of
You are coming from Guwahati.
I am from Guwahati, 25th of March, my lord, if you are not incoming.
25th, other matters are there, I think.
26.
No, 26th, those matters are. You give me a date, please. What date is happening? The process.
हमारे डायरी में होता डायरी की उसका क्या नहीं नहीं बता
3rd April?
26, 27. Bombay to Puttadam, 28.
Between 10th and 20th? 14th, 15th, 16th. We are keeping it on 16th April. 16th April.
16th.
But you please compress your argument and finish it in around half
No,
an
no,
hour.
I'll complete, my lord. My lord, my basic argument I have made, my lord.
Yes.
I have to show the pleadings.
Half an hour will do.
45
Okay.
minutes.
We will keep it first in the morning. All right.
16th of April.
Learned counsel for the respondent.
तो प्रॉब्लम नहीं है ना
Commences his arguments, but does not complete the same. You want to say anything? No.
One thing, if it is convenient to my lord, maybe for half an hour the argument will continue by him tomorrow, and then on 16th.
No piecemeal. You finish it off.
Buena te queda todo.
16 को.
इनके क्या आएगा
But does not conclude the same. We list its appeal for further arguments on 16th April at the first sitting of the court. So we will hopefully finish it up on 16th. I will reassemble with Justice Dindo in 5 minutes.
हमारा
Execution.
Judgment. Call the list.
Item number 1, pronouncement of judgment.
Madam, we are sorry, we have affirmed the judgment of the learned trial judge. And disposed of the appeal accordingly. You want stay? Huh?
Putting the state in a difficult position, Lordship.
All right, instead of 4 weeks, we will make it 8 weeks. Considering the views of my brother, we have given 4 weeks time to comply with the order. We are giving you 8 weeks time. That's all. To enable you to. You have to sign.
Item number 2.
Item number 2, I am for the petitioners. This is a final hearing matter. On 7 March, your Lordship was pleased to order. Thereafter, the court will come to a decision whether this writ is to be heard by a physical appearance or not. On 7/3. So my humble submission is that I will permit it to all you online, because now I have some health issues at present. But and 7th, because you can post it on 7th April or 14th according to Lordship's choice by online.
What is this matter about?
So the matter is about we are challenging annexure P5 order and annexure P5 statute. It's a repealing statute. Digital University repealing statutes. In 2020, P1 statute, Kerala Dr. Rajithalal University Act was passed on in 2020. Subsequently, after 3 years, that was repealed by an annexure P5, which was repealed. So what happened in between was, on 4th February 2020, Lordship, can you turn to page number 17? On 4th February 2020, annexure P1 Act was passed. Dr. Rajithalal University Act was passed on 4th February 2020. Subsequently, 2020 March, COVID broke out. So entire world paralyzed in 2020. Subsequently, in April 22, because the second petitioner is the chairman of the trust, he underwent a liver transplantation surgery, so he was laid up. Then thereafter, on 15/9/2023, without any notice, they have repealed the statute. Without issuing any notice, repealed the statute. There is a blatant violation of section 48 of the HB P1. There are certain parameters and procedures to be followed before dissolving a university. In fact, they have not taken any steps for dissolving the university. On the other hand, they immediately, abruptly, and arbitrarily repeal the act. Repeal the act by P5 without assigning any reason. May take your lordship's attention to P5. P5, page number 50 to 53. 53 relevant. This act may be called the University Repealing Act 2023. It shall come into force at once. The Rectal University Repealing Ordinance is hereby repealed. Notwithstanding such repeal, anything done by or any action taken under the said ordinance shall be deemed to have been taken or done under the provisions of this act. Then, page number 54. What was the objects and reasons? Page number 54. However, even after 3 years of act being published in Gazette of Meghalaya, the sponsors of the university has so far not shown any interest to approach the state government with an application to establish the university. As such, it is clear indication that sponsors are not at all serious about establishing university in the state. Under such circumstances, it is felt that if Rectal University Act is allowed to remain in existence, there is every possibility that fraudsters may use the act to lure innocent students to sell fake degrees to them, which may bring bad name to the state of Meghalaya. So only under the assumption that fraudsters may use the name of the university. You are not telling you because due to the COVID, entire world was paralyzed. So they have started only for establishing steps there. When they have taken steps for establishing the university, immediately, abruptly, without notice, they have cancelled the matter. Because as well as the legal aspects, because the University Annexure P1 Act is a self-contained statute which contains certain parameters. What are the parameters for dissolving a university? So I'm referring to page number. Page number 39. Page number 39. P1. I'm reading. Kindly turn to page number 39 of my paper book. Dissolution of university. Section 48, clause 1. If the sponsor proposes dissolution of the university in accordance with the law governing its constitution or incorporation, it shall give at least 3 months' notice in writing to the state government. 2. On identification of mismanagement, maladministration, indiscipline, failure in the accomplishment of the objectives of the university, and economic hardship in the management systems of the university, the state government would issue directions to the management system of the university. If the directions are not followed within such time as may be prescribed, the right to take decision for winding up of the university would rest in the state government. 3. The manner of winding up of the university would be such as may be prescribed by the state government in this behalf, provided that no such action will be initiated without affording a reasonable opportunity to show cause the sponsor. So absolutely no show cause notice was issued as per section 43 of the Annexure P1 Act. So without issuing any notice, they abruptly, arbitrarily issued a repealing order. So Lakshmi, that's the circumstances. In 2020 February, Act was passed. Immediately COVID broke out. Immediately thereafter, the P1 chairman underwent a liver surgery. So immediately in 2023 on 5 morning, they have abruptly, without issuing any notice, repeal the statute. So this is a totally an arbitrary action. Another aspect, because expect P1 is a self-contained statute, there are certain parameters. Actually, suppose if there is any failure on the part of the university, I'm referring to page number 25, my lord. Page number 25. Section 13(1). Because there is a visitor the governor is the visitor of the university. What are the powers of the university? The visitor of the 13(1), the visitor of the university shall be notified by the sponsor in consultation with the state government. Here, Annexure P2 is an amendment order, amendment GO, appointing the governor of Meghalaya as the visitor of the university. Then, 2, the visit, 13(2), the visitor shall, when present, preside the convocation of the university, so and so. 3 is relevant. Section 3, the visitor shall have the following powers, namely, to call for any paper or information relating to the affairs of the university. 2. On the basis of the information received by the visitor, if he is satisfied that any order, proceeding or decision taken in the authority of the university is not in conformity with the Act, regulations or rules, he may issue such directions as he may deem fit in the interest of the university, which will be binding on all concerned. So here the visitor has not called for any report from the sponsor why you have not started the university. Visitor has not issued any direction. So first of all, visitor has to issue a direction as per section 13(1). Then only the government can proceed. Suppose we are not complying with the directions of issued as per section 13(1) by the visitor governor, then definitely they can issue another notice under section 48(1). So first of all, first step is they have to issue directions because the visitor has to deal with the matter why they have not established by this date. Then the visitor should call for a report from the government as well as the party.
It's dependent on the sponsor. The sponsor is not. Yes, what do you say?
May it please your lordship. Lordship, can you see that this is the act, your lordship. Education comes within the concurrent list, your lordship, item 25, your lordship. So the state legislature has made this act, your lordship. So when the state legislature has the power to make the act, your lordship, it also has that power also is coextensive, your lordship, with the with repealing of the act, your lordship. The reliance of the writ petitioner in section 48, your lordship, is misplaced, your lordship, because what happened, your lordship, the university is yet to be born, your lordship. It's yet to be born.
All right. You file your written notes.
Yes, sir.
You file your written notes, we are reserving judgment.
Yes, my
All right.
lord. Yes, my lord. Oh, 1 week time is granted for written. Within 1 week. Within 1 week, I shall present my written slot.
Yes, yes.
Sure.
Lordship, we have filed the affidavit, your lordship, in paragraph 6, 7, 9, and 10, your lordship. We have detailed the reason why the law has been repealed, your lordship.
All right.
Whatever. Lordship, kindly consider one more aspect. Lordship, kindly, because my name is wrongly entered as SV Ranjan. Actually, my name is SV Rajan. So I have filed an application also. The registry may be kindly directed to
Rajan.
Yeah.
Yes, not Ranjan, Rajan.
Yes, my lord.
Yes.
So please issue a direction to the registry, correcting the.
We have heard learned counsel for the parties. Next hearing concluded, CAB.
Lord. Oblige, your lord.
Thank you, Mr. Rajan.
Much obliged. Much obliged.
Then usual written notes by
Sure, sir.
12th, 19th.
Yes, my lord. Yes.
Item number 3.
Lordship, whether we also would.
Where is the list? Thank you.
Lordship, whether we also would file the
Yes,
notes, your lordship,
within 1 week.
within a week. Oblige, your lord.
Yes,
Milord, in this matter, the Shillong Municipal Board has filed a report, Milord, regarding those shelter dogs.
yes.
Your Lordship, the state has allowed the municipal board to keep the stray dogs till such time the municipal board comes up with their own shelter house, Your Lordship.
The state will house the
As
dog.
allowed. In Upper Shillong, there is a shelter house for Animal Birth Control Center, which was, there was a misunderstanding and it was not allowed. Now they have allowed it, Your Lordship.
Now, Milord, the issue is, Milord, they have allowed only for 60 days, Milord. We require something permanent from the state, Milord, because we do not have space. We have, Milord, at page 13 of your Lordship's have.
You are for the municipal board.
Municipal Board, Milord. So, Milord, we have set up a temporary shelter in our campus. which is temporary. Now at Upper Shillong, the veterinary department has only given us for 60 days, my lord.
Your Lordship, on the last occasion, the municipal board had come up with a submission that they have already got a place and they've started construction also, Your Lordship. Your Lordship may kindly
That
see
is
Your
complete.
Lordship's order.
That
And
is
that
complete.
within 30 days, they are expected to complete the construction. And now they say that they want a permanent.
If your lordships has, your
Then in
lordships
that
has my
case-
affidavit, my report,
Where is the report?
my lord, affidavit filed dated yesterday, my lord.
Okay.
This is municipal board.
Yes, my lord, this is my report.
Where is the state report?
The state report is here. We received it yesterday. This is also a part of the municipal board's affidavit, Your Lordship, at page 9. Where is the next one?
How much time you will take to build the shelter?
My lord, shelter is ready,
Then?
but this shelter is not permanent, my lord. It can cater to only around 20 dogs, my lord. We require a bigger space, my lord, for which we require help from the government.
So how many dogs you will be placing in the shelter of the state?
Of the state, my lord, because the shelter is only provided to us for 60 days.
How many dogs are there to be put into the shelter?
My lord, that instruction I do not know the exact size of the place, my lord. But our shelter, my lord, only around 20 dogs.
Because this ABC, the Animal Birth Control Center, which we have in Upper Shillong, Your Lordship, is meant for birth control of the street. And at no point of time has the municipal board stated that the shelter they are constructing is a temporary one.
Yes, please take down. This public interest litigation is today confined to providing shelter to stray dogs in the street. Full stop. Complaining of the menace posed by these stray dogs, this public interest litigation was filed on 27 November 2024. This court noted that the Shillong Municipal Board had taken measures to capture these stray dogs, vaccinate and sterilize them. So that they did not increase in number. The board did not have a proper shelter to accommodate these dogs. Full stop. The problem was not solved because of the vicious nature of these dogs complained against. Full stop. There were frequent allegations of dog bites on the road. Paragraph. Today, Mrs. Yangi, Learned Additional Advocate General, hands up to this court a minutes of the meeting dated 12th February. Held by the government and board officials. Was it attended by board officials also? The presence is not enclosed.
That, here it is, here the copy to Your Lordship. The,
It was attended.
it is attended by all, Your Lordship. At number 3, Your Lordship.
So we find that a decision has been taken by the government to allow the board to use the animal shelter at Upper Ceiling to keep the dogs for 60 days. Next. Learned Counsel for the board submits that a temporary structure to accommodate these dogs has already been completed at the instance of the board. I've said 20 dogs, but it can accommodate only 20 dogs. Unless a permanent place is allocated by the government to the board. The problem will recur after 60 days. Paragraph. First of all, this point should have been raised by the municipal board at the meeting itself. Full stop. No such point seems to have been raised. full stop, it is raised for the first time in court. Paragraph, we direct that the state and the municipal board hold another meeting where the above problems are discussed and a proper decision taken for permanent placement of these stray dogs. After 60 days or within such extended time, if any, allowed by the state. The officials at the meeting may consider allocating more, permitting more temporary accommodations to be set up by the board to accommodate the street dogs. In the meantime, a permanent place for keeping them may be identified and allocated, and a proper shelter be constructed. Paragraph. The state and the municipal board are to jointly file a report in this court before the returnable date. List this application just before 2 months on 8th May. To review the situation.
Oblige, Your Lordships.
Item number 4.
Yes.
May I please, Your Lordship? Your Lordship, I have been appointed as legal aid counsel for respondent number 2, Your Lordship. Lordship, I'm praying for 3 weeks' time to file my reply along with documents.
This is a writ report.
Writ appeal.
Reply to?
Reply to the writ appeal, Your Lordship.
What is the position?
It's
Admitted?
yes, my lord.
Then what reply you will file?
Your Lordship, in the writ petition, due to miscommunication.
Make an application on the prayer of learned counsel for the state of Meghalaya.
No, Your Lordship, for the private respondent.
Who is appealing for the state?
I'm appealing for the state, madam. Madam.
You are appealing for the state of Meghalaya.
Madam.
Why online? Where are you situated?
Madam, I was there last week. Yesterday, I was assisting Mr. Salman Khurshid in a matter which was.
Are you situated in Delhi? Are you submitting?
Right now, I'm in Delhi because I had to come yesterday.
All right.
To
It's
assist
all right.
Mr. Khurshid.
Yes, for these short matters, you can appear online.
Madam.
All right, on the prayer of learned counsel for the.
Respondent number 2, Your Lordship.
You have no objection if the matter is adjourned?
No
Appeal?
objection. No objection.
This appeal is adjourned till when? 2 weeks. Till 3rd April. All right?
Yes, Your Lordship. Obliged.
Next.
Oblige.
Item number 5.
Yes.
His Lordship, His Lordship, this petition, the writ appeal, and he said, Your Lordship, I humbly pray that I may be allowed to serve the copy of the writ appeal through postal service because he is not feeling well. I have called him, we have collected, of course, we have filed the Talabana and we have taken a step. Then
What
we
you
are-
will file?
No, actually only serve the copy to the respondent because he was given us too dusty. So I humbly pray, Lordship, maybe we serve the service of the writ appeal through postal service, my Lord. On the last occasion also, we have tried, but he said he was making an attempt to deliver the copy of the writ appeal, but private respondent didn't accept it. Then again, another order was directed us, direct petition, writ appellant. However, Lordship is having personal difficulties. He's sick, Lordship. So we may be just allowed to serve the copy to the private respondent through postal service, Lord.
The order is already there.
Yes, Lordship, but it is order is there, but through the state.
We are extending the time. You do whatever you like. He is sick, we will extend the time.
Lordship.
But it is there. Service is through postal service.
No, we went to the, this one, but they didn't allow. They said the order was.
That I don't know.
Okay.
Time to comply with the order dated
Yes.
24th February 2025 is further extended till 2/8 May. We make this application returnable on 3rd April.
Lordship.
Yes.
Item number 6.
Yes, Lordship.
Who's for the petitioner?
This is suo motu, item 6 minute is suo motu PIL, registered by your lordship pursuant to order passed by the Honorable Supreme Court regarding Ramsar.
We will take it up on Tuesday.
Yes.
We will take it up on Tuesday. Considering the constraint in time, list this public interest litigation. On 18th March.
Grateful, my lord.
Yes.
Item number 7.
Same order.
See, your lordship, in 7, your lordship kindly give 2 weeks time to come. We are
Who's for the
petitioners, madam. It's not difficult.
All right. By consent of learned counsel for the parties, this appeal is adjourned till. That last week there are a lot of fixed matters.
Your lordship.
We will keep it on 4th April.
3rd April, may I request, or 8th April, my lord? 3rd or
8th April.
8th April.
Oh, no, 8. Because that is a little uncertain week. 7th is likely to be declared a holiday.
So then your lordship may have it on 14th. 14th.
By your consent.
Yes, my lord.
Could it be the 11th? 14th? I may not be here.
11th is also.
11th is a Friday. So only the notification.
That week you leave out. We will
Then it
keep
will be
it
14th.
on the 14th.
Then 14th. Obliged.
Item number 8.
Item, you will 3-4 benches in a day, and item will go on till sundown. All other matters adjourned till Tuesday.
Grateful, my lord.
Your Lordship, in this matter, Your Lordship, I pray for 1 week time is given, Your Lordship.
18.
What?
For item number 8, Your Lordship, I'm praying for one week's time.
But all are connected.
No, 8 is separate, my lord.
8 is separate, Your Lordship.
All right. So 7, 9, 10 are adjourned till Tuesday by consent of learned counsel for the parties. Yes, 8. What are you asking for?
7, your lordship has already granted time on 14th. It will be 9, 10.
9, 10.
Yes.
Who's for the
Your Lordship,
you are not the appellant in 9 and 10?
I'm 8, I am for appellant, my lord. On 8, I am for the appellant. So this, in this matter, my friend is seeking 1 week adjournment.
8, 9, 10.
No, only 8, my lord.
Only 8, Your Lordship.
Only 8.
No, in the other matters you were for whom?
No, I am not appearing in other matters, my lord. 8 is independent matter, my lord. It is by Meghalaya Power Distribution Corporation.
No, all right. What about, we have just adjourned 7, 9 and 10?
9, I'm for the state lordship. I'm for the petitioner lordship in item
So
number
we are
9.
keeping it on Tuesday by consent of parties, all right.
But I
Yes.
think I'm appearing, my lord. Not on joint request, if your lordships can have it on the first week of April.
All right. That is item number
10, Your Lordship.
10 is connected with,
No, not connected.
It's individual case, Your Lordship.
so what are we adjourning till Tuesday? Only 7?
No, 7 is adjourned for 14th April, my lord. 9 is getting adjourned for 18th, my lord. 9 is for Tuesday.
9th, who's appearing?
I'm appearing for the state lordship.
All right. 9th by consent Tuesday. 9th is Tuesday. And 8?
8, your lordship, my friend
2
is
weeks,
speaking.
2 weeks time is out, my lord, item number 8.
Adjournment.
Yes, Your Lordship.
By when? Give a date.
So I am responding in item number 8.
Yes. Who's the appellant?
I'm for the appellant, my lord.
Yes. So 14th April?
Yes, lordship.
By consent, 14th April.
Grateful, my lord.
And which item is remaining?
Item 10, my lord.
10.
First week of April, my lord. On
All right.
joint request,
3rd April?
my lord.
Lordship.